disagreement on a point of law or fact, a conflict of legal views or of interests between two persons. Accordingly, it must first be established, and I quote, that the claim of one party is positively opposed by the other. End of citation. This is an issue of substance and not of form or procedure. The existence of such a disagreement on a point of law or fact cannot be established in the instant case. Chile has never challenged Bolivia's sovereignty on the channels located on its territory. How could it, indeed? Chile wasn't involved in the construction of these channels on Bolivian territory, as was recalled during the hearings on the 1st of April last. Indeed, these channels were built by the British Antofagasta, Chile and Bolivia Railway Company Limited, FCAB, after a license was granted by the Bolivian government in 1908. How then might one consider that Bolivia's sovereignty over these installations has been contested? Neither, indeed, does Chile challenge Bolivia's wish to dismantle these channels. In fact, Chile was never in a position to oppose such a right. Indeed, it is only when Bolivia filed its counter-memorial in the present proceedings that, for the very first time, expressed its intention to dismantle these channels. I repeat, for the very first time. Indeed, during the hearings on the 4th of April last, Bolivia did attempt to claim that Chile had denied Bolivia's right to dismantle the channels back in 2002. Yet the documents cited by Bolivia reflect an entirely different reality, worth mentioning in the context of the instant case. In 2002, Bolivia did indeed raise the possibility of, and I quote, and you will see the text on the screen, ordering the cutoff, so the possibility of ordering the cutoff of the flow of the spring waters of the Silala channeled by artificial means towards Chilean territory. Though not to bring the case before an arbitral tribunal or the International Court of Justice. Reacting to that, on the 4th of March 2002, Chile announced its opposition to, and I quote, all measures that could obstruct the flow of the waters of the Silala River into Chile, and points out in this respect the spirit of cooperation. End of citation. Distinguished members of the Court, as can be observed, the issue of the dismantling of the channels was not raised in the exchanges I have just presented. In contrast, Bolivia's threat to cut off the flow of the waters of the Silala towards Chile was indeed raised. So there was no dispute regarding the dismantling of the channels before the season of the court, but there was indeed already a dispute between Chile and Bolivia concerning the waters of the Silala. The filing of a counterclaim makes no difference whatever. There is still no dispute relating to Bolivia's right to dismantle the channels located on its territory, and Chile does not contest that right. Bolivia contends that the artificial channels and drainage mechanisms have had an adverse effect on the waters of the Silala River and have contributed to the degradation of the bufedales and to wetland shrinkage. As Chile noted, Bolivia may take whatever measures it considers necessary and appropriate to remedy this situation in accordance with the relevant obligations of international law. Distinguished members of the Court, it follows from this presentation that there is no dispute between Chile and Bolivia regarding Bolivia's sovereignty over the channels located on its territory and its right to dismantle them. However, were the court to consider that there was a dispute at the time of Bolivia's filing of its counterclaim relating to Bolivia's sovereignty over the channels located on its territory and its right to dismantle them, quod non, the written submissions exchanged between the parties in the instant case have rendered it moot. As your court recalled in the nuclear tests case, and as Bolivia has pointed out, and I quote, the court, as a court of law, is called upon to resolve existing disputes between states. Thus, the existence of a dispute is the primary condition for the court to exercise its judicial function. End of citation. A claim is baseless if, as we've just seen, the dispute has never existed. But a claim can also be baseless if a dispute has ceased to exist. Indeed, not only must the dispute exist at the time of the seizing of the court, the dispute must, and I quote, continue to exist at the time when the court makes its decision. The court acknowledged so much in the Northern Cameroon case, and I quote, whether or not at the moment of the application was filed there was jurisdiction in the court to adjudicate upon the dispute submitted to it, circumstances that have since arisen render any adjudication devoid of purpose. Under these conditions, for the court to proceed further in the case would not, in its opinion, be a proper discharge of its duties. Indeed, to safeguard its judicial function, the court must draw all necessary consequences from this finding and refuse to entertain the case on the merits. For the same reasons, the court must refuse to consider the merits of Bolivia's first counterclaim. In the present case, Chile has recognized in the clearest terms that Bolivia has sovereignty over the channels located on its territory by stating in its reply that, and I quote, Bolivia's sovereignty over artificial channels and drainage mechanisms located in its territory is not contested by Chile. Chile has also recognized in the clearest terms Bolivia's right to dismantle its network of canals. Chile has indicated that, and I quote, if Bolivia wishes to remove the channels and to restore the wetlands to their pre-1920 state, this is something that Chile would positively encourage. Finally, both states agree that the dismantling must be undertaken in accordance with customary international law. However, on the 5th of April, Bolivia raised an entirely new and wholly baseless argument, alleging that Chile is claiming an acquired right. Chile categorically rejects that contention. Chile has never claimed such a right. As Chile clearly stated during the hearings on the 1st of April, and it repeats it today, and I quote, a reduction, if any, of the cross-boundary surface flow resulting from the dismantling of the channels in Bolivia would not be considered a violation of customary international law unless the obligations that Bolivia has accepted were somehow engaged. Nor would non-man-made contamination of the Silala water with larvae from insects breeding in the wetlands be considered a violation of these principles. End of citation. Chile repeats that Bolivia's sovereign rights, in particular its right to dismantle the channels, must be exercised in accordance with the principles of customary law relating to international watercourses. This is not a condition which is laid down by Chile. It is simply a matter of applying the law. Does Bolivia want to claim the prerogative of not being bound by customary law, although it is bound to it? If that were to be the case, the first counterclaim would have to be rejected. Madam President and distinguished members of the Court, the first counterclaim has become devoid of purpose, assuming it ever had a purpose. Accordingly, the Court cannot uphold Bolivia's claim because that would be contrary to its judicial function. This concludes my submissions. I wish to thank you for your attention. And might I ask you, Madam President, to give the floor to Professor McCaffrey.
I thank Professor Bassan-Changement for her statement, and I now invite the next speaker, Professor Stephen McCaffrey, to take the floor. You have the floor, Professor.
Thank you, Madam President. Madam President, distinguished members of the Court, good afternoon. It is a privilege to appear before you, even if remotely, on behalf of the Republic of Chile. My task today is to show why the Court must find that Bolivia's second counterclaim is untenable. Madam President, members of the Court, in its second counterclaim, Bolivia asks the Court to adjudge and declare that, quote, Bolivia has sovereignty over the artificial flow of Silala waters, engineered, enhanced, or produced in its territory, and Chile has no right to that artificial flow, end of quote. This request of Bolivia harkens back to matters dealt with in my first speech, kindly delivered by Professor Boyle, in its reliance on the claim that Bolivia has exclusive sovereignty over a portion of a watercourse shared with Chile. Yet, in its pleadings before you on Monday and Tuesday, Bolivia has retreated considerably from that position. In these pleadings, Bolivia's counsel made no mention of sovereignty in relation to a so-called artificial flow. And yesterday, Bolivia's position was entirely recast, with its former argument none too subtly tossed into the dustbin where it has always belonged. Sovereignty instead made only a rather bashful appearance in the form of a sovereign right of Bolivia to decide what to do in its territory, a wholly uncontroversial proposition. Bolivia has thus abandoned a legal basis that it really never had in the first place, for claiming rights in what it calls the artificial flow of the Silala. What Bolivia did replace this with, in relation to its new claim concerning maintenance of the channels, Chile is struggling to understand. Bolivia's second counterclaim is thus vastly reduced in scope and will be treated accordingly here. Madam President, members of the Court, Bolivia, in its address to the Court yesterday, effectively abandoned sovereignty as a basis for its claims to what it calls the artificial flow. Mr. Bundy, whom I thank for his kind well wishes, stated as follows. This is a long quotation. Quote, Bolivia has sovereignty over the waterworks, which includes, amongst others, the right to dismantle those works. Chile cites no principle of customary international law that would deny Bolivia that right. To the contrary, Chile has made it abundantly clear that Bolivia possesses this right. But the corollary of that admission is that Chile has no legal right to insist that the enhanced surface flow, or the artificial flow, produced by the channel works must be maintained. It is Bolivia's sovereign right to take that decision. And it is in this sense that the reference in the first part of Bolivia's counter-memorial, Claim B, to its sovereignty over the artificial flow of the Silala waters, engineered, enhanced, and originating in its territory. It is in this sense that that should be understood. Bolivia can decide if the waterworks that produce the artificial flow, remain or not. That is Bolivia's sovereign decision. And for the same reasons, the second part of Bolivia's counterclaim B, that Chile has no right to the artificial flow, necessarily follows. End of quote. Bolivia's basis for this counterclaim has evolved and changed since the beginning of the proceedings before you. Indeed, Bolivia initially claimed in its counter-memorial that it, quote, has full sovereignty over the artificial flow of waters of the Silala, on the ground that, absent any drainage and channelization mechanisms, waters that are mechanically induced or created would not naturally flow to the territory of Chile, end of quote. Bolivia argued that, quote, the principle of equitable and reasonable use under customary international law does not apply to the artificial flow of the Silala waters. The principle of equitable and reasonable use does not apply to the artificial flow of Silala waters. And, quote, a further consequence of Bolivia's sovereignty over the artificial flow of waters of the Silala is that any use of such flow by Chile depends on Bolivia's consent. End of quote. Madam President, this goes the Harman Doctrine one better. Bolivia, however, recognized in its rejoinder, and both Bolivia and Chile agree, that whether it flows on the surface or underground, the water is Silala water and would eventually flow to Chile. In the same rejoinder, therefore, Bolivia found itself needing to change the basis of its argument and claimed that, quote, Bolivia's sovereignty over the artificial infrastructure in its territory affords Bolivia sovereignty over the artificial flow generated by that infrastructure, end of quote. Bolivia has effectively abandoned sovereignty as a basis for its claim and is now claiming before you that, quote, our opponents claim that Bolivia intends to enjoy absolute and exclusive sovereignty, end of quote. This, however, is not what Chile is contending, but what Bolivia has been claiming in its written pleadings. For example, in its counter-memorial, Bolivia claimed that, quote, Bolivia has full rights and authority over the artificially created flows and volumes of Silala water coursing across that frontier, end of quote. And that, quote, Bolivia has full sovereignty over the use of the artificial flow of waters, which in the absence of an agreement between Bolivia and Chile is to be regulated by Bolivian domestic law, end of quote. Madam President, members of the court, Bolivia previously claimed that, quote, the definitions for watercourse and international watercourse incorporated in the convention do not reflect customary international law on the use of artificially enhanced watercourses, and end of quote, thus claiming a basis in customary international law for its novel concept of accepting alleged, quote, artificial, unquote, flow from international watercourse law. Bolivia now proposes what amounts to a legal vacuum, declaring that the Silala is essentially too unique to be governed by the customary international law of international watercourses, and that no custom has evolved to fit its unique characteristics and circumstances. The references and sources included by Bolivia in its written pleadings that allegedly supported its novel concept of an exception for artificial flow from the customary international law of international watercourses are conspicuously absent from Bolivia's oral pleadings before the court. A central component of Bolivia's claim to sovereignty over the artificially enhanced flow early on was the puzzling idea of a manufactured river or manufactured waters. As Bolivia seems to have acknowledged that the waters of the Silala, either surface or groundwater, would eventually flow into Chile, minus small changes in evaporation, this argument has effectively disappeared, but without being openly retracted by Bolivia. Bolivia, in its written pleadings, also went so far as to offer up a number of domestic United States cases concerning so-called salvaged water, which support ownership over this water by the party that created it. To support Bolivia's claim to the alleged artificial flows of the Silala. These authorities, as well as the idea of salvaged water, are now wholly absent from the submissions of Bolivia before the court. In fact, Bolivia appears to have entirely abandoned its position concerning sovereignty over the water flowing through the artificial works, as well as the legal basis for this position that was advanced in its written pleadings. Of course, Bolivia still clings to a remaining vestige of sovereignty in relation to the works in their territory and their right to remove these works, something to which Chile has not objected. But Bolivia has provided absolutely no basis for its contention that these waters flowing through the channels, which would flow across the international boundary to Chile, regardless of the works, should be exempted from the law of international watercourses, other than to say that the Silala is unique, very particular, and very exceptional. I'm translating from Professor Pellé's speech. Madam President, members of the court, as I have shown in my earlier pleading, the Silala is an international watercourse as defined in Article 2 of the United Nations Watercourses Convention. Article 2 of the Convention defines the term watercourse as follows. Watercourse means a system of surface waters and groundwaters constituting by virtue of their physical relationship a unitary whole and normally flowing into a common terminus, end of quote. The central component in this definition of an international watercourse is the idea that surface waters and groundwaters, due to their interconnectedness, comprise a unitary whole. But Bolivia's insistence on different treatment of what it calls an artificial flow would result in the, quote, fragmentation of the natural unity of a freshwater system, end of quote. The quote, by the way, is from Stephen Schwebel, a former president of this court, in his first report on the law of international watercourses when he was special rapporteur for the International Law Commission. Destroying the natural unity of a freshwater system would fly in the face of the work of the ILC. That work was based on the concept of a watercourse as a unitary whole, a concept now enshrined in the definition of the term watercourse in the Watercourses Convention. With respect, it borders on the absurd to suggest that some of the waters of the Silala become non-international by passing through human-made works, and that this removes them from the system of waters constituting an international watercourse. Madam President, Bolivia's argument that a riparian state could gain ownership of a portion of the flow of an international watercourse simply by unilaterally developing infrastructure on that watercourse, as has been contended here by Bolivia, is a dangerous proposition for the governance and management of international watercourses. As discussed in my first presentation, the development and regulation of international watercourses by human hands is ubiquitous around the globe. Despite the contention of Bolivia that the channelization works on the Salala has made that river a unique international watercourse beyond the scope of existing international law, the Salala is an international watercourse as contemplated in the Watercourses Convention. International water law contemplates the regulation and development of international watercourses. Several articles of the Watercourses Convention contemplate installations and regulation. These articles are not referred to here as a reflection of customary international law, but rather to demonstrate the scope of this convention, which applies to non-navigational uses of international watercourses. Article 6, paragraph 1F of the Watercourses Convention lists, quote, conservation, protection, development, and economy of use of the water resources of the watercourse as a factor in determining the equitable and reasonable use of an international watercourse. Despite the fact that Bolivia contended on Monday that in the case of the Salala, quote, this is a very exceptional circumstance and precedents are too rare, even if they existed, for a particular customary rule to have been formed in that regard. The ILC, in its work on the non-navigational uses of international watercourses, very well aware of and considered the uniqueness of international watercourses across the globe. Indeed, quote, the diversity characterizing individual watercourses and the consequent difficulty in drafting general principles that will apply universally to various watercourses throughout the world have been recognized by the Commission from the early stages of its consideration of the topic, end of quote. According to Bolivia, quote, the qualification as an international watercourse is not sufficient to characterize the Salala. It presents very particular characteristics which have a great influence concerning applicable rules, end of quote. Bolivia's efforts to complicate the matter at hand does nothing to diminish the capacity of the law of international watercourses to provide answers as to the status and use of the Salala. The law of international watercourses does provide clear indications as to the general rights and obligations of Bolivia and Chile in relation to the Salala watercourse. Many intensively used watercourses are regulated in some way or another, often by straightening their channels to eliminate naturally occurring meanders, and thus to facilitate their use for such purposes as navigation and hydroelectric power production. This does not convert the flow they carry from being natural to being artificial. Even the bypass canal involved in the Gabčíkovo-Nagymaros project case, which was constructed by Czechoslovakia, runs for 31 kilometers through what is now Slovak territory and is capable of carrying some 80 to 90% of the Danube's flow. Even this was never thought to carry artificial flows. Nor, of course, could any claim have been made by Slovakia for compensation from Hungary for any artificially enhanced flows carried by the bypass canal following Hungary's attempted termination of the 1977 treaty involved in the case. recognizes the customary international law applies to the waters of the Salalah, but then applies that law in a way that distorts it beyond recognition. For Bolivia, customary international law applies to a pristine, undeveloped river. But apparently not to one that has been developed. Thus, Bolivia states in its rejoinder, quote, "For its part, Bolivia recognizes that once the artificial channels and drainage mechanisms in Bolivian territory are removed, the Salalah waters will be entirely governed by customary international law applicable to international watercourses," end of quote. This stunning proposition would reverberate throughout the world's international watercourses, almost all of which have been developed in one way or another. There is no hint in the Watercourses Convention that only international watercourses that somehow exist in a state of nature are considered to be governed by the law of the non-navigational uses of international watercourses. It would be, with respect, absurd if the principle of equitable and reasonable utilization and other principles of customary international law were preempted by the development of international watercourses. It is often precisely in the case of such development that these principles are of critical importance. Chile does not deny Bolivia's right to develop works in its territory on the Salalah, but the development of those works cannot run roughshod over Chile's co-equal rights to utilize Salalah waters. Madam President, distinguished members of the court, to conclude, the standard of equitable and reasonable use and other principles of international water law apply to all of the waters of the Salalah watercourse system. There's no legal basis for Bolivia to claim exemption for any alleged artificial portion of the flow from the norms of customary international law. Madam President, for the reasons I've outlined, Chile would respectfully request the court to declare and confirm that international law does not recognize the concept of artificial flow as invented by Bolivia, that the relevant rules of customary international law as reflected in the UN Watercourses Convention apply to the entire flow of the Salalah watercourse system, and that there is no basis in international law for Bolivia's claim that it, quote, has sovereignty over the artificial flow of Salalah waters engineered, enhanced, or produced in its territory, and Chile has no right to that artificial flow, end of quote, from Bolivia's submissions. Chile's rights are, of course, established by customary international law reflected in the Watercourses Convention, including the right to reasonable and equitable utilization of all of the waters of the Salalah watercourse system. Madam President, distinguished members of the court, thank you for your kind attention. Madam President, I'd be grateful if you'd now give the floor to my colleague, Professor Boyle.
I thank Professor McCaffrey, and I now give the floor to Professor Alan Boyle. You have the floor, Professor.
Madam President, members of the court, this time I will remember to take my mask off. It makes it easier to speak. It's a pleasure to appear before you once again on behalf of the Republic of Chile. And happily, my speech this afternoon will be short. My task is to deal with Bolivia's third counterclaim, Counterclaim C, which asserts that Chile must pay compensation for delivery to Chile of any artificially flowing waters of the Salalah, and further, the delivery of those waters requires the parties to conclude an agreement. Yesterday, Mr. Bundy attempted to clarify Bolivia's third claim by adding that this counterclaim addresses the situation where Bolivia decides to dismantle the channels, while Chile indicates that it would prefer the waterworks to remain in place in order to receive delivery of the enhanced surface flows caused by those works, i.e. the current flow, over and above what would otherwise be entitled to under the standard of equitable and reasonable use. But, Madam President, members of the Court, Mr Bundy's pseudo-clarification does nothing to help us. On the contrary, it shows that Bolivia's third counterclaim is entirely baseless and must be dismissed in its entirety. Bolivia's third claim is now premised not on sovereignty over the flow of water, but only on Chile's interest in the maintenance of the channels. But, Madam President, members of the Court, Chile has no interest in the maintenance of the channels. If Bolivia decides to keep the channels anyway, Chile would be under no obligation to pay for the continued delivery of water through the Salala. My task this afternoon is to explain why. Of course, as you have heard from my colleagues, it's entirely Bolivia's choice whether or not it wishes to keep or dismantle the channels. But whatever decision it takes, neither choice can provide any legal basis for an obligation of Chile either to pay compensation or to enter into negotiation for payment. Let me, Madam President, make an additional point that arises from the way that Bolivia has presented its third counterclaim. According to Mr Bundy, Bolivia's third counterclaim looks to the future. But in making the claim in this way, focused on future delivery of water, he seems by implication to be accepting that, or to have abandoned any claim for water that has already flowed to Chile in the past, the so-called historic debt, which Bolivia claimed some years ago at a value of several $billions, if I recall correctly. And the fact that they have now abandoned that claim to historic debt itself shows that the whole idea of payment for the delivery of water is legally baseless. And Professor Pele yesterday distinguished between artificial flow and natural water in a way that also seemed to suggest that Bolivia is only requesting compensation for the maintenance of the channels rather than for delivery of artificially flowing waters of the Salala. So the latter claim for payment is beginning to look more like a political symbol, devoid of any legal substance, and about as meaningful as charging for fresh air flowing over the Andes. But, Madam President, just in case we have misunderstood what Bolivia said yesterday or the day before, let me reiterate the point that Professor McCaffrey has also made today. But may I also say, just in case, that nothing I may say this afternoon is intended in any respect to disagree with or undermine anything Professor McCaffrey has said, and I have no doubt that he has not intended to undermine anything I have said. But you will appreciate we've all been scrambling a little to keep up with Bolivia's gyrations and its changes of position. But we are to be read consistently with each other. Professor McCaffrey has already demolished Bolivia's claim to sovereignty over any part of the Salala waters. Such a claim is plainly simply not tenable in international law. It's wholly inconsistent, as we've already argued, with the community of interest envisaged by the Watercourses Convention and the International Law Commission, and as affirmed by the Court in the River Oder, Gabshikovnaj Maros case and the pulp mills case. As Professor McCaffrey argued, the principle that a state does not have exclusive sovereignty over any portion of an international watercourse remains today the very basis of the law of international watercourses, as set out in the UN Watercourses Convention and reaffirmed in the case law of the Court. So if Bolivia no longer claims, or does not in law have, sovereignty over the Solala waters flowing into Chile, then, and in the absence of any agreement to the contrary, then it plainly has no legal right to demand either prior agreement or payment for delivery of water which flows into Chile in the future. The whole legal basis for that claim has simply disappeared in the absence of sovereignty. And Chile rejects entirely the claim that an agreement is a necessary precondition for future delivery of the Solala waters, or that it must pay for any of that water, whether it flows to Chile artificially or otherwise. The assertion by Bolivia that Chile's entitlement to the waters of the Solala is dependent on and subject to Bolivia's prior agreement is, of course, plainly inconsistent with the Laclanu arbitration, where the learned arbitrators held that an upstream state had no veto over the flow of water to downstream states. And the other precedents also show that the sovereignty of a state over rivers within its borders is qualified by a recognition of the equal rights of other riparians to make equitable use of that water without payment or agreement. Now, Bolivia, of course, claims that international law does not apply to the so-called artificial flow of the water delivered via the 1928 FCAB channels, or at least that's what it argued until this week. And I'm not going to further repeat Professor McCaffrey's comprehensive rebuttal of the sovereignty claim. But if, as Bolivia suggests, it goes ahead and dismantles the channels through which the Solala currently flows, the 2 to 3 litres per second of additional water which it says the channels generate, will no longer reach Chile as surface water, and counterclaim 3 will essentially become moot. Indeed, Bolivia now appears to accept this. Indeed, Mr. Bundy noted yesterday, beside the significant decrease in the surface flow that the dismantling of the channels would cause, the groundwater flow would increase. And that Chile, he said, will be able to recover the corresponding groundwater as a major part of its equitable and reasonable share. So they accept the point we made all along, that the water will end up in Chile anyway. Thus, the best objection to Bolivia's absurd and wholly unmerited claim for payment is that all of the water in the Solala flows naturally downhill into Chile, either superficially or as groundwater. Bolivia cannot claim to be a victim of topography, and no remotely plausible basis has been put forward for the case that Chile must pay for the water that it receives naturally, whether above ground or below. But there is another, stronger objection to Bolivia's claim for payment, and it's simply that state practice and the law of international watercourses do not support it. An upstream state, as a matter of law, cannot charge a downstream state for water emanating from its territory, or for works in its own territory that were never requested by or agreed with the downstream state. And Bolivia cites no relevant authority for its wholly unprecedented claim to payment for the delivery of that additional water to Chile. Remarkably, Bolivia nowhere in its pleadings, neither in the written pleadings nor its oral pleadings, nowhere does it make any reference to the compendium of documents on international watercourses edited by a then rather young Dr. Bruno Simma. Let me put it this way. Had I been making the argument that Bolivia was making yesterday, I would have taken the precaution of going and looking through that compendium of documents. It's an invaluable research tool. And I did that when I was young and when I was writing about international water courses and the pollution thereof. But Bolivia's complete failure to make any reference to this epic work, the best explanation for that, surely, presumably, is that they couldn't find anything. I imagine they did go and search. They're professional lawyers, they must have done. But they obviously didn't find anything of any relevance to the case that they're putting to you today. No treaties, no precedents, nothing to support their case. And it has to be said, and that silence speaks volumes. And none of the case law supports them either. In the River Oder and Lac Lanu and Gabchikova Najmarosh and Pulp Mills cases, there was a diversion of water. Every one of those cases involved water in some way diverted from the main stream. But none of those cases treated that diverted water in any way any differently from the natural flow. It was all regarded as simply a watercourse, with water flowing naturally through it. So no authority at all for the proposition that there is a different regime for supposedly artificial water. And Professor Pele, and these cases also give the lie to Professor Pele's argument that the Salala possesses a singularité fondamentale. This is simply not borne out when the facts of the cases are properly understood. The law of international watercourses is just that, law for all such waters, with no exception for Bolivian waters, no exception for the Silala. If Bolivia's view of the law were correct, the Dutch would be paying large sums to the Swiss and to the French for water delivered via the heavily canalised Rhine. And the same could be said about the Rhone. If you want the evidence, just drive down to the Riviera and see what they're like. But the French and the Dutch are not paying the Swiss for an artificially enhanced flow of water. The most that can be said, and this is an interesting comparison, is that the Dutch and the Germans do pay France under an agreement for the removal of chlorides from Rhine water. But here, the upstream state, France, is providing a service by agreement with the downstream states, and the costs are shared equitably by all riparians. But there is no hint in that agreement, the Rhine water agreement, of any payment by downstream states for any of the water that is delivered to them. Now, this precedent is the polar opposite of Bolivia's claim in this case. It stands, it seems to me, as a total rebuttal of what Bolivia is claiming. So the case law, the state practice and the doctrine referred to by Bolivia in its written pleadings simply do not begin to support the existence of a distinct legal regime for artificially enhanced flow. They're irrelevant to Bolivia's case. And most obviously, the precedents drawn from law of the sea are wholly inappropriate. This is perhaps an area where I'm slightly more at home than in international rivers, but this really is an empty drawer. Right, true, coastal states do sometimes artificially enhance rocks or low-tide elevations by covering them in reclaimed seabed material or cement, but both the Law of the Sea Convention and the case law under the Convention of International Arbitral Tribunals and the ITLOS and the ICJ show that an artificially enhanced rock remains a rock. It does not become an island, and an artificially enhanced low tide elevation remains a low tide elevation. It doesn't become an island either. So this bogus law of the sea analogy does not help Bolivia at all, and it's a ridiculous claim to make in the first place. Conclusion, an artificially enhanced river remains a river in international law. Now, Bolivia accuses Chile of taking advantage of the supposed additional litres of water that cross the border, as if there's something wrong in that. But why would Chile not use this water? It's a scarce commodity. It comes naturally downhill anyway. And even if it were true that Chile has received additional water, this is a de facto situation. It does not give Bolivia the right to charge Chile for it. No principle of law, none, not in international law or domestic law, supports such a claim. Not even in the law of restitution, which is usually the home of lost causes for lawyers, can anyone, or at least no professor I have consulted, has been able to come up with any principle of national law that supports Bolivia's claim here. If there were any principle, and the equitable and reasonable principle does not demand that downstream states pay for water they would receive anyway, if it did, there would surely be precedents. But as I have shown you this afternoon, I hope, there are simply no such precedents, and Bolivia does not cite any. Moreover, Bolivia, if it wished, could eliminate the channels and remove the benefit that Chile currently enjoys from them, as our agent has emphasised and as my colleagues have emphasised. Chile does not object to the removal of the channels. We think it will make no difference, to be perfectly honest. So that brings me to my concluding observations, really about the broader implications of Bolivia's claim to payment, if it were recognised, the broader implications for international law. Madam President, members of the Court, rather obviously, if you were to accept any part of Bolivia's unprecedented claim with respect to payment for the waters of the Salala, the implications for downstream states across the globe would surely be worrying and substantial. Would Egypt have to pay for any portion of the waters it receives via the Nile? Would India and Bangladesh have to pay for water delivered via channels which might be said to enhance the natural flow of water from the Hindu Kush? And please remember, we're not talking here about enhancements requested or agreed with the downstream state. That would be different. But Bolivia wants to be paid without an agreement, and to enforce its claim, it wants to cut off or reduce the flow of water if there is no agreement. Madam President, members of the Court, this is simply not international law, nor should it be. In my 20 years as an advocate before international courts, Bolivia's argument strikes me as the most destabilizing and dangerous that I have yet heard. No watercourse treaty adopts any such arrangements for regulating the flow of water between riparians. So for all of the aforesaid reasons, I would urge you to reject Bolivia's unwarranted and outrageous claims on the waters of the Salala. Legally and factually, they simply have no basis. Bolivia has claimed sovereignty over an empty vessel, but in common with other such vessels, it has made much noise. In conclusion and in summary, let me quote from a judgment of the Krishna Water Disputes Tribunal, which said, and we agree very much with this. No state has a proprietary interest in a particular volume of an interstate river on the basis of its contribution. The fact that the water rises in Bolivia is neither here nor there. It flows into Chile. Rivers all rise somewhere. And we invite the court to hold that even if any part of the flow of the Salala were enhanced as alleged, it is still part of the Salala watercourse system, whether it flows through the stream or in channels or underground. Where it originates and how it reaches Chile is neither here nor there. It's of no legal relevance whatever. So, as we point out in the reply, the fact that Bolivia's theory is without precedent and unsupported by any source of national or international law leads to the unavoidable conclusion that the theory on which all of its counterclaims are constructed, but in particular counterclaim 3, is just that, a theory, and it has no legal value. Just for a moment, pause before we finish this afternoon and consider what Bolivia is claiming. They want Chile to pay Bolivia in order to maintain the channels. But they can't, yet yesterday they pointed to the need to restore the wetlands. Well, they can't have it both ways. If we pay them to maintain the flow of water through the channels, how can they then restore the allegedly desiccated wetlands? Where will the water to do so come from? It can only come from the Salala. That would mean robbing Peter to pay Paul for an alleged environmental problem that Bolivia itself has created by its negligence. So, Madam President, members of the Court, we say that Chile remains free to use the waters of the Salala which it receives naturally as it chooses without payment or further agreement, provided, of course, that its use is equitable and reasonable. And we invite the Court to rule accordingly, because the Salala is, as Professor McCaffrey reiterated again this afternoon, in its entirety an international watercourse shared by both states. And the usual obligations of customary international law to cooperate and to take all necessary measures to prevent transboundary harm apply in full. Madam President, members of the Court, that concludes Chile's submissions for today. I thank you for listening. I am, of course, happy to answer any questions if you have any. Thank you.
I thank Professor Boyle. Your statement brings to an end today's sitting, as well as the first round of oral argument. The Court will reconvene on Thursday, 7 April at 3 p.m. for a sitting dedicated to the questioning of the experts called by Chile. The sitting is adjourned.